On the record in the matter of LAFQ versus Catherine Colby Lycos, file number 23-02246 GC. Counsel, can I have your appearance?
Yes, good afternoon, Your Honor. My name is Joe Burnett. I'm filling in for Tim Smith on behalf of the plaintiff.
That's Catherine Colby Lycos is present via Zoom. Today was the date for a motion to show cause.
Yep, I'm here.
Very good. This was a debtor's exam motion to show cause. And Mr. Burnett, did you meet with her privately?
I did, Your Honor.
Okay, and are you satisfied, or do we need further judicial interaction at this time?
Your Honor, I think we're good. When I spoke with the defendant, I gave her a list of documents we were requesting, and she said she could get those to us. I gave her our address. I think at this time I would just request of the court perhaps a control date a few weeks out, just to give her time to get those documents to us.
Maybe 30 days out. March 11th at 2. March 11th at 2 p.m. is the control date. Ms. Colby Lycos, do you have any questions for the court today?
I do not.
Okay, so you'll provide those documents and this matter will be completed as it relates to this particular matter. Otherwise, if you fail to provide the requested documents, you do need to appear on the March 11th date, okay?
Okay, only if I don't submit documents, correct?
Correct. If you submit documents and they're satisfied, you do not need to appear. If you don't submit the documents, you need to appear and explain why you submitted or what additional time you need. And then if you don't appear at the next date after not submitting the documents, they could issue a bench warrant for your arrest, okay?
Okay, thank you.
You're welcome. Other than that, you're all set for today.
Thank you, Your Honor.
Thank you.
Thank you. On the record in the matter of Joe Ella Chambers versus Lynette Farr, 23-02425. Appearance, please.
Good afternoon, Your Honor. Brian Butchart. I'm appearing on behalf of the defendant and counter plaintiff, Ms. Farr and Riverfront Apartments.
Okay, ma'am, please state your name.
Excuse me, Joe Chambers.
Okay, I do see that Ms. Chambers filed a answer, which is in the file. Counsel, did you get a copy of that?
I did, Your Honor, yes.
Okay, and then my note was that she was to file an answer and a more definite statement and counter complaint within 2 weeks. Let's see. Okay, and then the other issue I had was that you had not hired an attorney, but you were at some point at least looking to hire an attorney. You still have not hired an attorney, correct, ma'am? I can't hear you, ma'am.
I've tried, I've continuously tried.
Okay.
I spoke to several attorneys. Do things.
If I can't hear you, I can only imagine that he can't hear you.
Sorry,
We can't hear you, ma'am.
straining to talk as it is.
I understand.
And I've tried to retain counsel quite some time. Different, I can't get a lawyer.
Okay.
I can't get it.
Okay, so you're gonna proceed on your own in this matter then?
Yes, ma'am.
Okay, and then counsel for the defense, I think did we attempt before to have a pretrial on this?
But Your Honor, I I know that my partner who initially had this case has attempted to speak with Ms. Chambers on a couple of occasions, and it just doesn't appear like it's going to be resolved. I guess I would like to make a brief argument if and when the court permits regarding the answer that was filed and the lack of a more definite statement as ordered. But I don't think pre-trying this is going to help at this point, Judge.
Okay, yeah, you can make that argument at this time.
Thank you, Your Honor. As you did indicate, when we were before you 2 weeks ago, the plaintiff was ordered to, of course, answer the counter complaint as well as file a more definite statement. As noted, she did file an answer on a civil answer form. We started that answer with the statement that she was answering the complaint, or I think she, of course, intended the counter complaint. But she went on, it's obviously not responsive as required by the court rules to the counter complaint. There, she specifically required pursuant to MCR 4.201, I'm sorry, MCR 2.111C, to answer each allegation individually with either an admission or a denial. She's failed to do that. It's a 3-page run-on narrative. In it, there also appears to be additional claims that were not claimed in the original lawsuit. She's claimed, I think, an additional $2,055,000 in accumulated damages. So I don't believe that the answer is compliant with the court rule or the court's order, nor has she filed the more definite statement as ordered. Your Honor, at this time, I would request that her case in chief be dismissed. I do understand that she's not an attorney, that she's proceeding in pro per, but this court has given her a lot of opportunities to comply, and as a matter of fact, she is required still to comply with the court rules, even though we do know that she likely doesn't understand them fully. I think the court's given her plenty of opportunity. We still don't quite understand what exactly her complaint is about. I think this is our 4th appearance before you, Your Honor, and at this time we would be asking the court to dismiss her matter.
To the extent that I'm going to give you an opportunity to respond. I did order that you file a more definite statement. I only see an answer to counter complaint, which was filed 2 days ago, and for the record, this is the first time I've seen this file since then, so I've not had an opportunity to read this. Where is your more definite statement?
Again, Your Honor, I was homeless.
That's not what I asked. That's not what I asked you. Where's the more definite statement? Because on the 23rd, I said that you had until now to file a more definite statement. Where is it? You've not filed one?
I haven't.
Okay.
I was trying to find a place to live.
I understand that, but you're the one who's bringing this lawsuit. They didn't haul you into court while you were trying to find a place to live. You hauled them into court. So you're still responsible for following the court rules and the procedure. And I can't deviate from that because of your own circumstance. When you brought this matter before the court, you didn't have to bring this matter before the court if it was something that you could not move forward with appropriately. And even if you can't get an attorney, you filed this complaint on your own. You are still responsible for moving the case forward in an appropriate manner. It does say at the top under the address counter, so I'm assuming this is the answer to the counter complaint. I got to dismiss your complaint for failure to prosecute because you have not essentially put enough information in the complaint to put the defendant on notice as to what you're suing them for. So when I ask for a more definite statement, that's what I mean. You're required by the court rules to put the other party on notice in your writing specifically of what you're saying they did to cause you damage, that they had a duty and that they breached of. So you've not been able to do that. I'm going to dismiss the case, but it will be dismissed without prejudice. So that means you can reissue the lawsuit at another time appropriately, and if you get an attorney. But as it relates right now, it's not moving forward, so I have to dismiss that. As to the counter complaint, I gave you an opportunity to address the counter complaint. The counter complaint, your answer is about 5 pages long. And I don't know that it's sufficiently, without reading it, is addressing the counterplace, because even as I skim it, I see issues about police and civil rights, and you're requesting $2 million. And if you're requesting $2 million, you're in the wrong court.
No, now,
You know what now?
I'm in the wrong court.
You can't get $2 million out of this court.
I'm getting false information. I'm getting held up. I'm getting
Who's-
blocked everywhere.
Who's
I
holding you
turn.
up?
I come to the courts, I ask people, I've never been in a city where they give you the wrong information, mislead you on everything.
Well, we're not holding up your
I'm not-
case, and the court is not to give you legal advice.
No, ma'am, I'm
So,
not saying.
so you're the one who's bringing the lawsuit, ma'am. You understand that?
Sometimes I understand, I have a headache, I have a whole, and I get confused in terms.
I can understand that. And so what I would advise, ma'am, is that you probably, not try to bring this lawsuit on your own, maybe get some assistance of a counsel, an attorney, because, it's not clear what you're suing for, okay?
They say that there was damages. And I'm simply saying, how can there be damages when she is falsely using my apartment?
Who is she?
Lynette Farr, she would say first of all, it's $585. That's the exact amount of rent. That's the exact amount I charge them with stealing. That's all on police records. That's all on record. Second of all, she was using my apartment to show investors, and she's sending me letters like they're inspections. It was her own workers who told me she was using my apartment as, to show investors. My apartment's in immaculate condition. All they did was come in there and steal.
You have pictures of the damages?
I have pictures.
I'm talking to Mr. Burkett, sorry.
Your Honor, if the court's going to dismiss her case in chief, my client doesn't want to be in court, Judge. I have authority to dismiss our counter complaint.
Sure.
We brought the counter
Okay, well,
complaint.
I'll accept your dismissal of the counterclaim. We'll issue a dismissal on both sides. And we'll note that you are dismissing the counter complaint. The court's dismissing the complaint for failure to prosecute, and it's dismissed without prejudice, okay?
Thank you, Your Honor. And I'm sorry, did you wish for me to submit that dismissal on the counterclaim?
Yes, please.
Okay, will do.
Do you have any questions, ma'am? Okay, good luck to you if you do intend to refile this with counsel, okay?
Thank you, Your Honor.
Thank you. Okay, this is the matter of LVNV funding versus Ricky Bennett, 24-08136, council appearance.
Afternoon, Your Honor. Brad Johnson, P75416 on behalf of the plaintiff.
Sir, you can stand. What's your name, sir?
Ricky Riley Bennett.
Okay, I do have a pretrial statement that was prepared, I think, by both parties today. Any issues that we need to address on the record today?
None from plaintiff, Your Honor. Yeah, Mr. Bennett was very helpful in the breakout room.
Thank you. Mr. Bennett, you're agreeing for your signature to be placed on this document?
Yeah.
Okay. Do you have any questions for the court?
Not really.
We'll get you a copy of it. You'll be all set, and then you'll get your next court date in the mail, okay?
Okay, so I'll get another court date in the mail.
Correct. That we'll use that to kick out your next court date. Remember that this also outlines your next deadline. So if you want to file a motion or you want to request discovery from the other party, you got to do it all within that time frame. You also have a responsibility that when they serve you with things that you respond to it. So if you get a motion for summary disposition, it'll come with the date. But it also requires you to respond to it. Okay? Thank you. You're all set.
All right, thank you.
Thank you, counsel.
Thank you, Your Honor. I got another one, Your Honor.
You're all set. This is the matter of LVNV funding versus Sheila Davis, 24-07121. Appearance.
I'm sorry, Judge. Did you say LVNB versus Davis?
That's correct.
Sorry, Jack Francis on behalf of plaintiff's attorney of record.
Okay, I have here that there was counsel on the defense, but I don't see them present. Have you had communication with opposing counsel at all?
No, Judge, we did send them some settlement negotiations and we have not heard back.
How do you want to proceed, counsel?
Judge, I guess in this instance, since there is an opposing counsel, we would be okay with maybe one short adjournment to see if maybe they didn't get the notice for today.
Oh, sounds good.
February 18th at 2.
February 18th at 2. Do you have any additional matters for today?
That's all, Your Honor. Thank you.
You're all set. On the record in the matter of credit acceptance versus Markeisha Gordon, 24-05248.
Hello.
Counsel, can I have your appearance?
Excuse me. I'm sorry.
I'm talking to counsel.
Good
Sorry.
afternoon, Your Honor. Brad Johnson, P75416 on behalf of the plaintiff.
Thank you. Okay, and then this is Miss Markeisha Gordon.
Yes.
Okay, Ms. Gordon, you filed a motion to set aside a default judgment. You stated in your motion that also you wanted to stop the garnishment, that you were not ever made aware of this case, that no one came to your house, you didn't receive any mail, and that the date stated that the date that it stated you were signed, you have camera footage that you were in custody. Is that I'm confused.
No, I was at work that day. So I'm in the process of getting Ring to go backdate until August, because I remember a guy coming, but he never had stated who he was or what he was for. But I was at work at that time, so there was nothing left for me to get in contact with anyone.
Okay, it states here in the proof of service that you were served personally on August 30th at 4:02 p.m. And that when they delivered the documents to you, they had you confirm your identity. It said the individual tried to refuse service by not opening the door and questioned accuracy of documents. Documents left seen by subject, and the individual appeared to be a black-haired Black female, about 25 to 35 years of age, 5'4" to 5'6" tall, and weighing about 140 to 160 pounds. It says with piercings. So it's pretty descriptive, ma'am.
I don't.
That's the first issue. I can appreciate that you're going to try to get Ring to determine that it wasn't you. However, you filed what appears to be a motion, and it was set as a motion to set aside a default judgment. However, it really is what I believe. I think you're really trying to attack the garnishment, is what it sounds like. But I could be wrong. You can let me know, ma'am.
No, I'm not trying to attack the garnishment. I am, like I said, I was at work that day. I'm not running from anything, but to be for that amount, that's not even how much the car was for or anything. And like, I don't have any piercings, anything. Like they said, they confirmed with the neighbor. I was at work that day. I worked second shift. So I was not there whenever they came. I did answer my Ring camera. Yes, but no, I'm not trying to default it or anything, but that's just not right. I didn't try to run from anything or nothing like that.
He did enter your Ring camera, ma'am. What does that mean?
I answered my Ring camera because when someone comes up, they press the button and you get on there. You can't see my face through a Ring camera. And I was at work. I wasn't at home on that day.
Okay. So you do have a recollection of speaking to someone?
I don't know who the guy was. It was a black male. I believe it was a black male, if I'm talking about the same thing. I was on the camera. He said he had documents, but he never said, oh, this is what it's, who am I here for? He said who he was here for, but there was no other information on who was I supposed to get in contact with. There wasn't a letter, like nothing that was left on my porch or anything, on my door, nothing. And then I get letters in the mail. I'm confused because I never had a court date or anything. If he didn't identify himself who he was, how am I supposed to get in contact with anyone to figure out anything or what's going on? And I don't have any piercings, and I'm not 120 to 160 pounds. I weigh 260 pounds. So how could he see me? If he's talking about a neighbor, that's not me. I don't have anything to do with a neighbor.
Okay, so, the concern is, I looked at you, you don't look like you have any piercings either, I don't know who the description was. So that, if that is the case, and it's in a sworn, statement from your process server, that it could be fraud, that they didn't serve her and they stated that they did serve her. However, in order for me to set aside a default judgment, ma'am, the court rule says I need two things. I first need good cause, which you're providing me good cause, which is that, Judge, I was not the one who was served. That's not me. It's probably some fraud or a misunderstanding going on here. But the other thing you need is a meritorious defense to the actual case, which you haven't provided me with the meritorious defense, because it sounds like you do recognize and understand that there's a judgment that you, or a past due amount, I should say, that you believe you owed. And so I'm trying to understand what your meritorious defense would be, ma'am.
Okay, so last year when I looked up how much I owe credit acceptance from another dealership, they told me $1,400. Cause I'm guessing that's what whoever bought the car, cause I've been sued for a car before, and they sold that car, and whatever else was owed or however that went, that's what I paid. But when I went to go get a car last year, they told me you owe credit acceptance $1,400. I'm like, okay, so they must have sold the car. So that, and then I think I had got some mail stating that too. I'm not sure. I don't know, but that's all I knew about that situation.
You're not disputing that there's a debt, you're disputing the amount.
Yes, correct.
Okay, Mr. Johnson, you can respond.
Thank you, Your Honor. Whatever a dealership told her about credit acceptance is not from credit acceptance, as you know. I mean, that's hearsay, basically. There is no defense. She admits she took out this, looks like a Chevy Malibu, and it was sold at auction, but there's still a deficiency, and it's not anywhere close to $1,400. It's, you know, at the time was around $6,985.30. So I'm not unclear how she's getting to that 1,400 besides this hearsay statement from some dealer. Also, I will note for the record that a judgment was mailed to Miss Gordon back in looks like October, and there was nothing. There was no motion. There was no, hey, what's going on here? Nothing, just this. And now, obviously, when the garnishment's happening, that's when we hear from her. But you know, she knew about the judgment and she didn't do anything.
Did you want to respond, ma'am?
The only thing I got in the mail was a judgment. I never got any other papers to go to court.
Well, that's what I actually want you to respond to. When you got the judgment, the court rule gave you a time period to which you could come and file your motion to set aside the default judgment. Why didn't you do that?
No,
then?
the only thing I had got was a garnishment letter. I never got court papers or anything. How am I supposed to not have court if I don't have any court papers?
No, I'm talking about the default judgment, because a copy of the default judgment was mailed to you.
And that was with the whole garnishment of the income tax or whatever. That all came together.
I'm not talking about a garnishment. I'm talking about a default request, entry, and judgment that was mailed to your address I'm sorry? That was mailed to your address on October 15th from the court, by the way.
Okay, yeah, I don't remember getting any court documents.
It didn't come back here. So that is the glaring issue, is that you have a certain time frame to set aside a default, which you were really outside of that time frame. And I was trying to work with you and be lenient, but the fact that you would have received judgment from the court and then you not respond to it and then wait until there's a garnishment, which happens often. People will ignore the court, the summons and complaint. It sounds like you were aware that someone, at least from your ring camera, was trying to serve you with the lawsuit. So you were put on notice. Whether they actually served you, I don't know, but you were put on notice that there's a lawsuit pending against you and they're trying to serve you.
No,
the second issue.
Sorry, go ahead.
The second issue, well, you told me there was ring camera footage of them ringing you and you responded to the ring. And so you knew there was something out there against you. You also knew because you tried to get another car that you owed a debt. And so typically we'll have cases where people will ignore or evade service one way or the other, or not get served. And then we later get a default judgment against them because they failed to appear. Once you're served with the lawsuit, you got to respond within a certain time frame, and that time frame is listed on the bottom of your summons and complaint. And then we still don't hear anything from them after they get a copy of the default judgment, which the court itself mails out to you with the address that's on the file. Before I called your case, I checked the address on the file and cross-referenced it with the address that you put on your filing today to make sure, hey, do we have the right address? It's the same exact address the entire time. So it did not come back to us undeliverable. And then we still didn't hear anything, which is common in a lot of these types of cases. But what we typically hear people come in is once their wages and or taxes get garnished, they get in here so quickly and file something and tell us they didn't know anything about it. But I struggle with that because we know that we sent something to you ourselves. Even if he didn't, even if his process server, let's say I take your word for it, that you were not the one that was served. The description that was given in the service doesn't actually match you. So it's likely, because I don't see any piercings, and for you to put piercings in, I don't believe they're talking about earrings. I don't see any piercings at all. I don't know how tall you are. 140 to 160 pounds is pretty petite. So, and I can only see your face, but I'll take your word for it that you're not in that size range. I don't know who was served. But I can believe that if that was the description, it was not you. I cannot believe that you were not on notice of the lawsuit though, and that you were not provided a copy in mailing from the court of this default judgment being entered against you. The same way you would have gotten notice about the garnishment is the same way you would have gotten notice about the default judgment. You understand that, ma'am?
Yes.
Okay, and so as to your meritorious defense, your defense that you're saying is that, well, you don't believe you owe that amount based on not what you actually believe you owed, but based on what another party told you. Unless you can provide some documentation that this was the amount that I purchased this vehicle for, and then when I defaulted on the amount that was owed, I have records here, which should have been provided to you, that show that they sold it, and this is how much was left on that, then your statements that someone else told you or may not have told you are not sufficient enough to be a meritorious defense. I don't know what your original loan was for.
Oh, and I never got anything, how much that car was sold for. I never got any of that. So how do I know I owe this much if I never got any contact from them? They never told me they sold the vehicle or anything like that. I don't know if the vehicle was sold. I'm going off what he just told me. But when I thought when you sell the vehicle, whatever else is left, that's what you pay. Like I said, I've been through RPM and I had to pay them $2,000 because they sold the car, and whatever was left was the $2,000. I paid them. They had garnished my checks from work and I paid them.
So that's why you took out a total on $14,049.84. Is that accurate?
Okay, that sounds about right. It might have been 13, but if it was 14, then okay.
I'm looking at what the paperwork says. It says total amount $14,049.84, that is. And then there obviously was some default. This was information that would have been provided in the complaint. And that's why I have it, because I have a copy of the complaint.
I've never received that.
Okay. Counsel, you said the vehicle was sold?
Yeah, so it was sold at auction back in March of 22, it looks like.
Oh, I see that here. It says it was sold for $1,700. And that there was still interest that's obviously accruing plus late fee. Then there was a repossession fee that was imposed. What I'm going to do, ma'am, is I'm going to have you and Mr. Johnson go into a private meeting room, you provide him with an email address. He's gonna forward you a copy of this document, this ledger, that will explain to you what took place. This is for a used vehicle, ma'am, that you purchased.
It wasn't a
Like 20
repossession. I gave them the car back, but I know it falls under repossession. I gave the car back
That
because
is
I
a
was
repossession.
yeah. When I
Whether they
understand
come in,
that.
whether they come and take it or you come and bring it back, if you owe a loan and you don't pay it off and they have to repossess the property, that's what it is. They are now in possession of it. This is a 2010 Chevy Malibu, which at the time you purchased it had 83,000 miles on it. In March of 2019. I don't know exactly when there was repossession. Was that 2022?
Yes, Your Honor.
Okay, so a Malibu, I don't know what the condition was, going at auction for $1,700. And that doesn't even sound unreasonable. There's no way that if you had a $14,000 loan at the time that they had to regain possession of the vehicle with that outstanding amount, that you still owed at least half of that. No way you owe 14, no way they sold that vehicle for $6,000 at auction. But that's very unlikely. But nonetheless, you all talk privately about that. He's going to email you that so you can have a chance to look over it. And then you can also discuss resolving this with a installment payment order, because I have to deny your request to set aside the default judgment because it is outside of the timeline to file that request. You're supposed to file it after you receive the default judgment, not after you get the garnishment. And the court rules say, as it relates to the garnishment, you can't use the garnishment to now come in and try to attack the judgment. Meaning you waited until you got garnished and now you want to say, set aside the default because I don't owe this money, or I don't believe I owe that much. There was a time period for which you were to attack it, and you have waived that by not responding in that time period now. And so I also don't believe that you have a meritorious defense. I do think you have a good cause, but I do believe that you owe this money. And so I'll let you and Mr. Johnson talk about whether or not there's an agreement or that could be entered for an installment payment order, okay?
Okay, thank you.
We'll put you in the private meeting room now.
Your Honor, would you like me to e-file that order?
Yes, please.
Okay, will do. Thank you, Your Honor.
Thank
We don't have to come back?
You only need to come back if you come up with something that you want to put on the record. Otherwise, you're free to go after you meet.
Okay, sounds good. Thank you, Your Honor.